You know, one of the fastest ways a probate case can go sideways? Failing to notify the right people. I'm Elijah Keys, a certified specialist estate planning attorney in California. That's like being a board-certified physician, except I'm a board-certified probate attorney. I've done hundreds of probates, and I'm here to talk to you about them. In this probate video series, we've covered what a probate is, when it's necessary, and the steps involved. Now you might be wondering, who actually needs to know that probate has started? If I'm the only one handling things, why do I have to notify anybody else? These are the same questions we walk through with clients every single day. If you're watching this, you're likely navigating a loved one's estate and just trying to do it the right way. Let's walk through what you need to know about giving notice during probate, who needs to be informed, and why, even if you're the only one managing the person's estate. So who needs to receive notice in a California probate case? Under California Probate Code 8110, once a probate petition is filed, you are legally required to notify all the heirs of the deceased person, all the named beneficiaries in the will, all the other persons listed in the will, and any other interested parties, even if they aren't getting anything from the estate. And if the beneficiary of the will is a trust, you have to notify all the beneficiaries of the trust, and you have to notify the trustees named in the trust. These notices must include a copy of the petition for probate and formal notice to administer the estate, which includes the following: the date, time, and place of the hearing, and a formal notice that the person who's receiving that notice has a right to object or has a right to disagree, but that's included in the formal notice. Why is this required? Well, probate is a legal process that affects property rights. The court wants to know that everyone who might be impacted has the opportunity to speak out, has the opportunity to ask questions, has the opportunity to raise concerns, especially before any major decisions are made. There may be someone that you don't want to notify. That one person who always causes fights, you know the one, everybody has one, because they might argue against you. But that is the exact reason you should give notice. The court wants to hear their opinion too. Hiding things is not going to help, but rest assured, judges are really good at sniffing out bad intentions. You might ask, I'm the sole executor, why do I have to notify anyone? Why don't I just do my job? This is a common question we hear from clients, especially when they're named as the sole executor and believe that they have everything under control. They're named. Why do they have to notify anybody else? Well, here's the answer. Even if you're the only one in charge, probate law in California does not assume that everyone else agrees. A will does not appoint you as the representative. A will is a letter to a judge that asks the judge to please nominate you if you are found fit, and if the judge believes that you're the right person for the job. Proper notice is about due process, which is a right given to everyone under the U.S. Constitution. It gives others the legal right to respond, challenge the petition, and ask for clarification. Most importantly, legal notice protects you as the representative. It makes sure that no one else gets to say that you did the wrong thing later. Now, a few examples about notice. If a sibling was left out of the will and believes it's invalid, should they have a right to claim that it's not valid? Of course. They have to receive a formal notice. They have the right to object. What if a named beneficiary has moved out of state? Should they be able to present notice? Should they be able to object? Absolutely. And they get that notice in writing. What if somebody lives overseas? Yes, they should be given the right, but it has to be given in writing. Even creditors have a right to receive notice, but that's only after the probate is opened. So creditors receive notice afterwards because they're not guaranteed to receive anything. The people who are guaranteed to be affected by that will need to receive notice beforehand. Even if you don't want to notify someone because you say that it's really inconvenient, it is. You might say it allows other people to argue against you, but the judge is required to treat everyone fairly. The judge will not allow you to treat yourself more fairly by not telling anybody else what you're doing. You have to tell everyone so that the judge can make sure that the decision is made fairly. So how do you actually give notice? Well, giving notice in probate isn't sending a text or making a phone call or an email. It must be done formally within the guidelines of the probate code. Here's how it works. You have to mail something. All notice is done by mail. You must mail a copy of the notice of petition for probate to all required parties at least 15 days before the hearing. That doesn't mean that you should wait for 15 days beforehand, just as far as you possibly can. Oftentimes it's better to give people more advance notice, because if you notify someone 15 days before and they show up at the hearing, they get to object on the day. So you're not really saving a whole lot of time. You also have to file a proof of service with the court showing that you followed the law and sent notice properly. That has to be filed at least 5 business days before the hearing. You have to publish a legal notice in the newspaper. In most cases, you have to file this public notice in a local newspaper once a week for 3 weeks. But you have to make sure that you can file the proof of publication at least 5 business days before the hearing. If you miss any of those dates, some courts will simply not allow you to proceed and will continue the case. That might sound like overkill, but trust me, this is exactly what the court requires you to do. It also protects you from accusations of mishandling the estate later on. Most importantly, if you don't do this, the court will not allow you to proceed. You're also going to have to send a similar notice 3 to 4 times during the probate, but to a more limited group of people. So you might as well get used to it. It's just a fact of life when you're dealing with the courts. At the end of the day, notice is about transparency and accountability. That's what the judge wants. They want everyone to see what's happening. They want everyone to know that you're responsible. They want to make sure that people who are responsible are fair and equal. They don't want to know that people who are responsible will hide things and try to get away with stuff. The judge will not allow you to serve if that's your attitude. Proper notice ensures that everything is done above board and that the person representative is fulfilling their legal responsibilities. And don't worry, you don't have to figure it out alone. If you want some help, contact a certified specialist estate planning attorney in California. The ones that are really good will have done hundreds of probates. We certainly have. We help our clients prepare all the right notices, meet deadlines, handle court filings correctly. We do this so that they can focus on what matters, honoring their loved ones' wishes and protecting their family's future. If you've reached this part of the video, thank you so much for watching. Make sure that you like and subscribe so that you never miss a video. Make sure to share this video with someone who you think could use the information, and follow along so that we can help you develop the keys to your legacy.